Our next speaker is Professor Ira Ellman, who has become one of our heroes. He is a professor of law and affiliate professor of psychology at Arizona State, and he's currently a distinguished affiliate scholar at the Center for Study of Law and Society at UC Berkeley, where his research focuses on law as applied to sex offenders. He has...
Yeah, I'm
Sorry?
I'm sorry?
Are we, okay.
Oh.
I'll finish. He has served on a multitude of judicial and legislative committees in Arizona, and he has served as a law clerk to Supreme Court Justice William O. Douglas and as a legislative aide to Senate Adlai Stevenson. He was senior author of a leading textbook on family law that has been through 5 revisions, and the chief reporter for the Principles of Law and Family Dissolution that was published by the American Law Institute. But he's probably best known to us because of his deep dive into the origins of a statement by Justice Kennedy of the Supreme Court that determined that sex offender recidivism was frightening and dangerous. And he pursued that to its origin and wrote a paper on this several years ago that kind of unmasked the whole frightening and dangerous thing. And that's gotten a fair amount of press since then. But more recently, Professor Ellman served on the consultative group of the American Law Institute that has just recently formulated revisions to the Model Penal Code. So with a big thank you for his efforts toward our cause, would you please welcome Professor Ira Ellman, who is coming to us by way of Zoom today because of some health issues. So hopefully we've got that untangled, and we'll have Professor Ellman on the screen. Thank you.
Can people hear me? Okay, I'm not sure if I heard that right. I sort of heard a roar in response. I'm going to assume that that was a yes. Well, I'm sorry that I'm not there in person. I would have much enjoyed being there, seeing some old friends and making some new ones. And I really am disappointed that I couldn't do that, but I take it this is working. And so I'm gonna go forward and we'll experiment with this remote presentation. So I'm talking today, I said I would talk about Animus, and I'm gonna do that in the context of recent events which made me think more about it. You undoubtedly paid some attention to the hearings for Justice Ketanji Jackson's nomination to the Supreme Court. And the issue of child pornography sentencing in federal courts became a big issue there. And I imagine that most of you paid at least some attention to this, and you saw these quotes from Senator Blackburn accusing her of having this terrible pattern of giving child porn offenders sentences below the guideline recommendations. Then Josh Hawley saying, well, this goes beyond soft on crime. This record endangers our children. And Ted Cruz spoke up as well. Well, the thing is, Blackburn's comment is actually accurate, and Hawley, of course, is wrong. And I think understanding why so many federal judges depart from the federal sentencing guidelines tells us something about animus in the policymaking around sexual offending. And that's what I want to bring in today. So my plan for this talk is to see if I can explain why animus is really lies behind the harsh federal sentencing rules for possession of child pornography. Why federal judges are able to depart often from those rules, the difference between group-based animus and individual sentencing. And then I want to talk about how animus is in many ways the basis for the registry regime that we are all familiar with. And when I say registry regime, I mean not only the registry itself, but all the things that go along with it, and that varies a little bit from locale to locale, but we're talking about, residency restrictions and restrictions of where you can go and where you can work and et cetera, et cetera. We all know what those are like, and they're all part of the registry regime in the way I think about it. In many places, those restrictions are triggered by being on the registry. And a possible constitutional response to the fact that the registry is based on animus. So some basic points about child pornography. Street crime, of course, is normally just a matter for locale, for state and local law enforcement. But internet crime is inherently interstate. And so that gives the federal government jurisdiction. So there's also state jurisdiction continues. So both sovereigns, as it's called in the law, have jurisdiction over it. But about a third of all prosecutions nationally for child pornography possession are conducted, take place in federal courts with federal prosecutors. The precise allocation varies a bit from locale to locale, but that's a kind of national estimate. And federal child pornography prosecutions went way up. That is the number of them from 1994 through 2012. And you can see that on this graph. And it's an interesting graph in a way, because this only goes through 2006. But if I had a graph that continued on in 2012, it would look similar. It would just be longer, but the trend lines would be the same. And you could see that federal prosecutions for sexual abuse or sex transportation, as it's called, and those, you can get some of these because if you commit a contact sex crime in a national park or in a federal building or in the military or something, it can be then a federal prosecution as opposed to a state or local. But you can see those don't hardly change the number of prosecutions over time. But child pornography prosecutions really started going way, way up, and they continued. So what happened? What caused this big jump? Well, there's a huge effort on the part of the federal government. There's all these different programs. Internet crimes against children, which is task forces in 50 states where the federal government combines with state and local law enforcement, and they have a kind of coordinated response when they catch people. Then they decide who's going to do the prosecution. And I'll just click through these. There's all different. These are all different federal programs. Project Safe Childhood, the Innocent Images Initiative, which is an FBI program, Operation Predator, which is conducted by us. That's these are the people who only are concerned with homeland security and terrorists or illegal immigration. People don't know they have a whole unit on child pornography. I haven't been able to figure out yet what proportion of their budget is spent on that, but they run an image clearinghouse. It's definitely a big part of their work. The military. The military actually has their own investigatory units all around the country near military bases trying to catch people who are accessing child pornography. And then NCMEC, people are undoubtedly aware of NCMEC. NCMEC is actually it's a private organization. They always call themselves that, private nonprofit organization, which technically they are, but they're 100% funded by the federal government. So that's all part of these efforts. So the character of the people that are getting arrested, and because these efforts fuel state as well as the federal prosecutions, this is a nationwide general observation, that the character of the people arrested changes as the number of people arrested goes up. And so you can see this. These are data conducted by an organization in Hampshire that did a very good job on this. The way the character of the arrestees changed between 2000 and 2009. So first, let's look at the people arrested for possession of child pornography. In 2000, most of the investigations were triggered by somebody reporting that they were suspicious that Joe was molesting children, was touching children, maybe, for whatever reason. Somebody was suspicious of this, and they report him to some law enforcement agency, which does an investigation. And then sometimes when they do that, they find child pornography. Most of the people arrested for child pornography in 2000, that's how they came to the attention of law enforcement, suspicion of a contact offense. By 2009, 80% come to the attention of law enforcement with no contact offense suspicion at all. 90% end that way. They come to law enforcement attention because all these efforts to surveil what's going on the internet are catching people who aren't doing anything else. So that's how they're brought into the loop. 75% of the people caught this way in the modern data on people prosecuted for possession of child pornography, 75% have no criminal record of any kind. There's also been a change in the people arrested for production. In 2000, there were only 402 such arrests nationally, 380 of them were adults. In 2009, this is the last time the New Hampshire group has gotten this data, there were almost 2,000 arrests nationally for production, 1,910. 1,200 just about of them were minors being arrested for production of child pornography. How does a minor produce child pornography? Well, of course, if they just snap a picture of a peer without clothes on their cell phone, they have now produced child pornography. So what happened with federal sentencing rules as more people were charged? As the law's reach widened, sentencing rules became much harsher, which maybe seem a little backwards, but that's what happened. And to follow this story, we have to explain how the federal sentencing rules work. So as in states too, statutes set a sentence range, and a judge picks a sentence within that range. In the federal system, the federal judges are not entirely free. Some states have similar systems because there's something called the Federal Sentencing Commission that creates guidelines. At one point, the guidelines were mandatory. They're not mandatory anymore, but judges are expected to look at them, and they are supposed to explain themselves if they issue a sentence that is not consistent with the guideline sentence. So the guidelines are a way of telling the judges, here's the statutory sentence range, but this particular case, you ought to give this sentence within that statutory range. And so a federal judge who's going to depart from that recommended sentence has to actually explain why in a written order. The guideline is created, has two parts. When the Federal Sentencing Commission creates this guideline, every crime is what's called a base level. So there's some number of points you get. They have a point system that is in accord with, that's set by the base level. So, robbery is a base level, murder is a base level, possession of child pornography is a base level, distribution of child pornography is a different one. Receipt of child pornography, which seems like the same thing as possession because actually it is, but it's technically a different crime. There's an historic rationale reason for that, et cetera. All these have different base levels. But then in each case, the base level in that particular case is adjusted to reflect aggravating or mitigating factors that are present in that case. And so then the commission sets a level based on empirical studies of deterrence, of harm caused by the offense, of reoffense risk that's of people who commit the offense. So the commission purportedly in the basis of some scientific investigation, and they really do actually try to do this, comes up with a recommended sentence and how to sort within any particular crime category the more worrisome offenders and the less worrisome through these mitigating and aggravating circumstances. In 1990, the possession for child pornography first became a federal crime. That first happened in 1990. It was not a federal crime before that. In 1991, the commission issued its first sentencing guidelines for child pornography. Later in 1991, Congress threw out the commission's formula and by statute required longer sentences than the commission had set. This is the only federal crime in which Congress has overruled the Sentencing Commission. It's a unicorn, as they say. It's completely alone. The resulting guideline for the typical offender, that is, the offender who has the typical combination of mitigating, aggravating circumstances along with the base level offense. Well, in 1987, possession wasn't a crime. There was something called receipt and distribution. Those were crimes in the federal lexicon. The typical sentence was 12 to 18 months. The recommended guideline sentence was 12 to 18 months for the typical offender. Okay, November, commission sets its guidelines 21 to 27 months. By the end of November, 27 to 33. Now Congress takes over. 1996, it's up to 41 to 51, 70 to 87 in 2000, 121 to 151 by 2003, 121, that's 10 years. 10 years and a month, 151 is another few years. By 2004, it's up to 210 to 262 months is the recommended sentence. We're talking about 20 years in prison. How did this happen? How did the guideline sentences get pushed up so much? Well, the technological changes collapsed distinctions between offenses. So we had these different offenses. Remember, receipt was an offense before possession was. What did receipt mean? Well, we're talking about the pre-internet age. Somebody received a hard image in the mail go back far enough. The obscenity prosecutions didn't have to be kids that there were pictures of. It could be adults, but receipt of a minor, an illicit picture of a minor through the mail, that's receipt. Okay, now in the internet age, there's no way to distinguish receipt from distribution. You can't receive it and not possess it. You can't possess it and not have received it. So everybody who is charged with one could have been charged with the other, but they're just different crimes. And receipt has higher penalty range. Receipt is a mandatory minimum. And then there's also distribution. Well, distribution, the pre-internet age, distribution, you have to make some effort to take this hard copy, this picture you had to add and make a hard copy and distribute it. Nowadays, everybody who does this gets their images through file sharing programs on the internet. And if you're file sharing, you're probably distributing, whether you know it or not, along with receiving. So everybody could have been charged with distribution as well. And production, an awful lot of them are. So this is a statement from the Sentencing Commission in 2021. Nearly all offenders, they review the records, who were only charged with possession could have been charged with receipt, distribution, or production. And of course, many of them are. And that's just up to the local prosecutor, the local US attorney, what he wants to charge. And if he charges receipt or distribution or production, that jacks the penalty up because there's mandatory minimum sentences for those, and the sentencing range is higher. And then technological changes made aggravating factors apply to nearly every case. So computer use, every case now. More than 600 images, that was a big aggravating factor. Well, everybody just about who is found with images is found with more than 600, because if they download one single zip file, which is how they get them, it's probably got more than 600 images. and prepubescent images. Well, the zip file comes with 1,000 images, and there likely will be some that are prepubescent. So there you are. And so the Sentencing Commission couldn't adjust the rules to reflect this reality because Congress had taken over the guidelines. So the Sentencing Commission had no capacity to adjust the guidelines to reflect this new reality. And Congress, when it made changes itself, made the guidelines harsher. They made the guidelines harsher. They never really discussed any of the data of the Sentencing Commission that the Sentencing Commission had found. The discussion in Congress, whenever there was, and often they made changes and increased the penalties without really any discussion at all. It would be an amendment that was passed on the floor to a bill in one house or the other. But when they did have a discussion, it's sort of like the discussion of child pornography that you heard at the hearings on Justice Jackson's nomination. There's a focus on a category, sex offender. They ignore the facts of the case. Someone who has pictures of CP is a sex offender, and that generates a reaction. Well, you have to go back and look at cases. If instead of thinking about categories, if you look at individuals, you get a different view of things. And an obvious lesson in that is the case that Judge Jackson was lambasted for. She gave a 3-month sentence. Cruz and Josh Hawley and Blackburn all lambasted her. How you gave a 3-month sentence to somebody for possession of child pornography, this horrible crime. Well, Hawley didn't care what the facts of the case were. They never came up in the discussion. He certainly never brought them up. His target was the group of people, right? But that sentence was given not to a group. It was given to a particular person. His name was Wesley Hawkins. Wesley Hawkins was a sexually confused 18 when he was arrested. He was looking at pictures of boys. He was confused about his own sexual orientation. After he was arrested, he cooperated with the police. He was very remorseful. And he never broke the law again, which this is a few years ago. This happened. He served his time. He was released. He's never broken the law again, which is what Judge Jackson expected. In his case, the guidelines called for 8 to 10 years. There weren't too many aggravating circumstances. He was only charged with possession. The prosecutor only asked for 2. The probation officer who was assigned to evaluate him recommended 1.5 years. The defense said, how about 1 day? She gave him 3 months. He was recently interviewed by the Washington Post, Mr. Hawkins was. And he said, I wasn't happy she gave me 3 months. But then when I was in jail, I heard about others who had possession as a first offense. They got 5 years, 6 years. She chose to consider that I was just getting started in life, and she knew this was going to hold me back for years to come regardless. And she didn't want to add to that. And of course, he's right. It's going to hold him back. He's on the registry. So he's quite appreciative now of what she did, but she really was just being very sensible, as are many federal judges. This is a Sentencing Commission in 2012. They did a report on this. They can't change the rules because Congress took them over, but they did a report. They say, the severe penalty ranges appear to assume the typical offender has sexually abused children before his pornography offense, likely will after, but that's called into question. This is the commission's very mild way of called into question by the emerging social science research. That's a very damning rebuke of Congress's rules by the commission, which relies on Congress, of course, for its budget, which all the members of the commission have to go through a congressional committee to be confirmed. But this kind of statement was compelled by the commission's own data. They did a study that they released in 2012 in which they tracked every single person who was released from federal prison after a child pornography possession, who I call lookers, because these are people, they screened out anybody who had other sexual offenses as well. Most of them don't, but some do. So they were interested only in people whose only offense was having had possession, receipt, whatever, but the guts of it, what really was is they had these images and they'd looked at them. There were 610 people, 610 lookers, as I call them, who were released from federal prison in 1999, 2000. The commission followed them for 8.5 years. 96.4% had committed no other offense of any kind in 8.5 years. And all the data on reoffending tells you that people who haven't reoffended in 8.5 years ain't gonna. If they reoffend sooner than that. The Bureau of Prisons, the psychologists at the Bureau of Prisons who are in charge of therapy programs that are offered to inmates, and the question they were wondering is whether they should be spending money on therapy programs, more money than they were, offering therapy to people in federal prison for possession of child pornography. They said, we're not going to have any effect on the reoffense rates with therapy. And why is that? Because the reoffense rates are already so low. We can't bring them down any further. So this is the psychologists who work for the Federal Bureau of Prisons. So how did this come about? Of course, it's electoral politics. If you go back to the committee hearings, you have Hawley and Blackburn and Cruz who are all leading the attack on Justice Jackson. They're all Republicans. But what did the committee Democrats do? They didn't defend her. They didn't say, this was an appropriate sentence she gave Wesley Hawkins. No. They never talked about that at all. They just try to change the subject. Democrats have also often been on the wrong side of this issue. There's a Congresswoman from Florida, Wasserman Schultz. She was the DNC head at one point. She was an ally of Hillary Clinton's. She introduced the bill, co-sponsored the bill that increased the maximum penalty for simple possession from 10 to 20 years. The bill that renewed the ICAC program. Obama signed her bills, also International Megan's Law. We don't have time to go into that in this talk. I'm sure many of you, maybe all of you, know what that is. It's bipartisan. I don't have any special animus toward the Democrats, that's for sure. But this is bipartisan. And it's because animus is a political strategy. And what happens is you can rally supporters against a common hated group is a very familiar political strategy, right? Others, it's us against the others, and the others are the source of our problems, and we will defeat them, and that's how we will solve our problems. Others, of course, historically, racial and ethnic groups, but more recently, immigrants, although actually, if you go back in American history, there was a time in the beginning of the 20th century when immigrants were also the focus of this sort of thing. So it's not a new thing. Well, defending others, it's not only that some people attack the other group, whoever they are, and it can be obviously more than one. It also is that the people who try to defend them pay a political price. And so they may be reluctant to do that. The political strategy of animus need not be limited to ethnic groups. Others can be not only ethnic groups. And the key here is that animus targets groups. It doesn't talk about individuals, maybe occasionally a particular one is an example, but the target is groups. Group animus makes individual facts irrelevant. This group is no good. Felons are, of course, very vulnerable to such group treatment as a general matter. And interestingly, when psychological studies that ask various inquiries about crime, people assume when you ask them about a crime category, in their head, they are picturing the stereotypic worst cases that fall in that category. So there are studies like this about, do you think the penalties for, robbery are too high, or, pick your crime, and people will, or too low. And people will say, oh, they're too low, they're too low. Then you give them a particular case that's actually a very typical case and ask them how would they would want to sentence that case. And they don't want to be that harsh. But if you ask them about the category, they're in their head, they're imagining the very worst. That's a very common thing, and it certainly happens when you ask people about the category sexual offenders. Sexual crimes are very susceptible to this. Other studies find that they elicit moral outrage and disgust. Very easy to generate animus against groups who, in the minds of people, elicit moral outrage and disgust. And that's what the law does, right? It creates a special label to facilitate that kind of group thinking, the label sex offender. And the label is then transformed in a public understanding from a legal category to a psychological diagnosis. It's, of course, not that. It's just a legal category. Anybody ever convicted of any long list of crimes falls now into this legal category. But in people's heads, it's a psychological diagnosis. And a sex offender is a person with serious, deeply rooted, largely irremediable character flaws that render him forever a dangerous threat. That's what is in the heads of people when they hear that term. So, and some are especially evil. Child molester, that's a subcategory. And the CP offender is, of course, a child molester in the minds of people. Maybe he hasn't had the opportunity yet. More likely, he just hasn't been caught. This is what people think. And so very easy, very convenient target for animus as a political strategy. And that's what you see. And it makes it very difficult for people to take the other side. Can federal judges avoid animus? Well, they can actually a bit. And we see that, in fact, they do a bit. They have life appointments. They're very little political pressure. It's almost impossible to remove a federal judge. So they can be wrong, but it's not because when they're wrong, it's not usually because they're worrying about re-election, right? They have no re-election to worry about. If they're seeking a promotion, if they have a hope, gee, I'm a federal trial judge, I want to become an appellate judge, I want to become a Supreme Court judge, then maybe they have in the back of their mind, they got to be careful about some things. I mean, the Jackson hearing might bring that to their head. Most of them don't have those ambitions. It's such a small group that ever get considered for, being a federal appellate judge, and hardly anybody for the Supreme Court. So for most of them, there really isn't any political pressure. Well, that makes it possible to resist animus. When they render a sentence, they necessarily are sentencing an individual. So they're not thinking, they have to really think about this person. They have to think about Wesley Hawkins, not about people who have child pornography in general. So they're forced to do that. And these are counterweights to the animus. I mean, they're still in this culture that has this view. And so they may come into it originally with sharing that, but they go through this process and there are counterweights to it for them that most people never experience. And so there is some difference, but there's also a limit. But let's look. Federal judges and the sentencing rules. So the Sentencing Commission did a poll of federal judges in 2010 about the guidelines in general. And for all the various crime categories under the federal criminal law, they asked judges, what do you think about the guidelines? You think they're about right or what? 70% of federal judges focused on the CP guidelines as being too harsh. And that was higher percentage than for any other category of crime in federal law. And they may depart from their guideline. As I said, when they actually do a sentence, they have to explain why, which is a chore for them. But downward departures are more common in sentencing for child pornography possession than for any other offense. So what Judge Jackson did was not so unusual. And as others later pointed out, there were judges who were appointed in the Trump administration, promoted by some of the senators who were criticizing Judge Jackson, who in their career as a judge had already departed downwardly in federal sentencing guidelines for CP. Now, how far down do they depart? Well, this is a chart from 2019, the most recent year from which I could get this data. And so you have here bars, and there's a difference. This is distribution of child pornography. This one is receipt. Remember that really anybody who is convicted of possession could have been convicted of receipt or distribution. And this is possession, but because they fall into different categories in the guidelines, they have different sentencing rules. The top of the bar is what the sentence would be under the guideline, the recommended guideline for the typical offender. And so you see here, for example, for distribution, it's 181 months. The actual average sentence was 135 months. So that's a big departure in a percentage basis. It's still all over 10 years. Receipt, possession, the similar data. And this is just if you aggregate them all together. People often in the field, when they talk about this, scholars, they lump these three categories together as non-production child pornography offenses, because everybody agrees that these are different in kind from producing child pornography. And this is a different way to look at the same thing. This is over time. When this chart is just 2019. This chart shows you from 2005 through 2019 what the average sentence was for possession, for receipt, for distribution. I don't know if you can see these numbers here. These are months, 60 months, 120 months, 180 months. It's been pretty consistent what the judges do, even as the guidelines got worse. The actual sentences rendered have been pretty consistent. But they're still awfully high, and you can get a sense of how high they are when you look at median federal sentence in months. I have this from 2012. I don't think it'd be very different today. For different categories of federal crime, what is the actual sentence imposed? Murder, 216 months. Sexual abuse, these are contact sex offenses, of course. Some of them, that become under the federal aegis are pretty serious crimes. 168 months. Child pornography possession, 90 months. The median federal sentence. Arson, 60 months. Robbery, 60 months. Drug trafficking, 51 months. Racketeering, extortion, 57 months. All of these significantly less than child pornography possession. And then don't forget supervised release. The guidelines, going way back when, encouraged a maximum supervised release term for people convicted of receipt, distribution, possession. But when that was written in the guideline, the maximum was 3 years. You all know what supervised release is. Those who haven't been involved in the federal system may not know for sure what that term is. It's the federal equivalent of parole. It's different in some important ways technically, but the day-to-day life of being on supervised release is similar to the day-to-day life of being on parole. Any event, so when this maximum guideline was put in place, the maximum that was allowed was 3 years. That became lifetime in 2003. So now the guideline says you should sentence everybody that is convicted of possession of child pornography after they get out to lifetime supervised release. Well, this is some data from this is the years 1999 to 2010. on how many months of supervised release people get. And again, this is production, this is possession, this is receipt and distribution, the other non-production offenses. And you can see when that changed, when 2003, the 3-year maximum went off, it jumps. It jumps. And there it's quite high. I mean, even for possession, we're talking about getting close, it's over 200 months. In fact, the average for receipt and distribution, those non-production offenses is 22.75 years. For possession, the average is 18.3 years. These are departures, downward departures that the federal judges are doing from the recommendation of lifetime, but it's still awfully long period on supervised release. And in fact, 30% of people convicted of possession get lifetime supervised release. If the prosecutor chose to charge them with receipt or transportation or distribution, 42% get lifetime supervised release. Can animus justify more severe punishment? Well, it actually can, in a way, as a matter of law, because the worse we think an offense is, the more we want to punish it. So that's why we punish murderers more than shoplifters, right? Murderers actually almost never reoffend. Shoplifters reoffend a lot. So if you thought punishment should just be a measure, should be used for deterrence and nothing else, and we don't need to have such a harsh penalty for people who are not likely to do it again, well, we should give light sentences to murderers and tougher ones to shoplifters. We obviously don't do that because we think murder is a heinous crime and shoplifting maybe not so much. And so the idea that bad behavior justifies harsher treatment, the law certainly accepts that. It's okay to punish people more because of what they did, not because of who they are, but because of what they did. Can the registry then be justified as punishment for sex crimes that the state particularly condemns? So there's been a lot of litigation over this, and you probably, many of you are I'm sure, aware of that. I mean, it's obvious that to people who are on the registry, it feels like punishment. But the legal test of whether or not it's punishment is more complicated. I'm not going to get into that today, but what I'm interested in is why is it that states resist claims that the registry is punishment? And why do people who are trying to attack the registry want to make the legal argument that it is punishment? And the answer is that if it were punishment, that would create a problem for states, because there are things you're not allowed to do with punishment that the states want to do. So for example, people have to register for a crime they committed in another state that's already punished them. So if you live in New York and you moved to North Carolina and you committed a sex offense in New York that North Carolina regards as registrable, North Carolina is going to make you register. They're going to make you register even if New York wouldn't. Well, if the registry is punishment, they can't do that, right? North Carolina can't say, we think New York didn't punish you enough for that crime they convicted you of, so we're going to add some. So when you get to our state, we're going to put you back in jail for a couple of years, and then let you out. They can't do that. But if the registry is punishment, they couldn't put you on the registry either. And we make people register for crimes that they committed before that crime was a registrable offense. So states don't want the registry to be punishment. They'll defend against that argument because it would limit what they do with the registry. So states claim that the registry is a civil regulation, like an air pollution rule. Air pollution rules promote public health. The registry is another civil regulation that promote public safety. Can a civil rule be based on animus? Well, something. There's some cases on that. Not many, four Supreme Court cases on it. Two are particularly favorites of mine, but they're old. They're from another era. A case called Moreno that threw out a federal law that the court said was based on animus against hippies. Claiborne threw out a local zoning law that they concluded was unconstitutional because it was animus against the disabled. But those are old cases from a different era, very, very different court, 1960s and 1970s. But that doctrine was revived more recently in a case called Romer in 1996, and then reaffirmed in an even more recent case, Windsor, which really used in a way of approaching the question it dealt with, it really borrowed from Romer and used that approach. Now, Romer and Windsor were involved with laws that discriminated against gay people. And Romer, which is the key case here, that was decided long before it became the Lawrence case that you may probably don't know that case by name, but it was a 2016 case in which the court held that it violated the Constitution to put somebody in jail, to put adults in jail for consensual homosexual acts, non-commercial consensual homosexual acts. It used to be you could be put in jail for that. Well, and some states were still doing it in 2016, and the Supreme Court held you couldn't. That violated the Constitution. Well, so think about this. The reason I raise it is this Romer case in 1996 is long before Lawrence was decided. They're protecting gay people from discrimination using the animus argument in 1996, long before the prosecuting people for gay sex was not going to be allowed. So it didn't depend. Romer doesn't depend on the fact that the people being protected by the case are people who have a same-sex orientation. What was Romer about? Because to understand the possible applications to the registry, you have to understand what that case was about. And Romer considered an amendment to the Colorado Constitution that had been adopted by a vote of the people, vote of the Colorado citizens. They amended their Constitution. And the amendment barred any law by any Colorado city or county or any state agency or university that was intended to protect gay people from discrimination. Now, nobody had to pass such a law. There was no constitutional protection for gay people from discrimination in 1996. As I say, you can put them in prison. You can make it a crime for them to engage in a homosexual act. But there were a lot of locales that had begun by that point, a lot of places, to protect gay people from discrimination by employers, discrimination in services, things like that. And a lot of Colorado cities had. Denver had an ordinance. The University of Colorado had a regulation. This amendment said, no, you can't do that. It said to all these locales and the university, you can't do that. It's going to be barred by the Colorado Constitution. The amendment effectively overrode dozens, actually, of local laws that banned gay discrimination. Well, the law was struck down based on animus against gay people. That's what the court said. They said this in 1996. And they had an interesting way of thinking about it. They said you have to distinguish between two kinds of laws. Some laws serve a broad public purpose. And that public purpose can justify the fact that some people are disadvantaged by the law. So you enact a zoning law, you enact an environmental protection law, you enact a health and safety law. It has a broad public purpose. Some people may cost them money. Some people may not be able to do something they wanted to do. But that's just incidental, the fact that that happens. That's not the law's purpose. And so those laws are okay. They say you got to distinguish those laws from laws, and these are the court's words, that have the peculiar property of imposing a broad and undifferentiated disability on a single named group. That type of law, they said, raises the inevitable inference that the disadvantage imposed is born of animosity toward the class of persons affected, that the purpose of the law was to express animosity, hatred toward the class of persons affected. That's why the disability is being imposed. It's not to serve some larger purpose, happens to have an impact on some people. That's a really significant way of thinking about it in distinguishing laws. Animus, the court said, is not a valid purpose for a civil statute. If that's the purpose of the law, it's no good. It violates the Constitution. So Colorado, as a consequence, had to overcome the inference of animus that was there because of this broad purpose and this broad set of disabilities imposed on the single group. They said Colorado had the burden of showing that they had really some other purpose, that the inference of animus wasn't true. They couldn't do that. The law was, so the amendment to the Colorado Constitution was thrown out. And the court said the more sweeping the burdens imposed and the narrower the targeted group, the more closely one should examine the state's purpose for the law. The more sweeping the burdens imposed and the narrower the targeted group, the more closely one should examine the state's asserted purpose. Think about the registry. Think about the registry through that lens. Would Romer support a challenge to the registry based on animus? Well, I think it certainly should. It fits awfully well. It's obvious. The registry regime imposes, these are my words in an article that I drew on for this talk, the registry regime imposes an astonishingly broad array of burdens. Boy, you start listing them, it is breathtaking. On anyone ever convicted of almost any sexual offense of any kind or seriousness, including, but of course extending far beyond inclusion in the public website. No similar regime has ever been imposed on any other group of law-abiding former felons who have fully served the sentence for the crime they committed years earlier. It's never been done. So the state, in an animus challenge, would be completely unable to show that the registry regime in fact serves its purported public purpose of public safety. They couldn't show that. And I'm sure you've heard all this data on why the registry doesn't advance public safety. I don't need to go over all of that here in this talk. I mean, just more than 95% of sexual offenses are committed by people who could never be in the registry. They'd never committed an offense before. More than 95% of those arrested. This is not as widely known, but if you start looking at sexual offense rates committed by people, released felons who never who never were convicted of a sexual offense. Some categories of felons they have a higher sexual offense rate after their release than people who were convicted of on the registry for sex offenses. Robbers are in that category. It's about a 3.5% sex offense rate by people released after robbery who've never had any prior history of a sex offense. And that's higher than the risk a lot of people are on the registry. Now I say in a way it's obvious. Of course, Romer applies. The registry is no good, but it's also obvious what the problem is with the argument. Romer and the Windsor case that came later that applied it were opinions by Justice Kennedy, and he's not there anymore, and nor is Justice Ginsburg. Might a state Supreme Court, though, pick up the idea pursuant to the state constitution? I think maybe so. There are some rays of hope on that. The registry has been limited by cases in some states' Supreme Courts. South Carolina South Carolina Supreme Court issued an opinion about a year and a half ago, 2 years ago, that you have to have a path off. Lifetime for everyone is no good. The Alaska Supreme Court found a provision on privacy in their state constitution. They said meant you couldn't put people on the website without giving them a chance to show why it didn't make sense for them to be on the website. So some state Supreme Courts have begun not waiting for the US Supreme Court and taking some steps of their own. Maybe you could get a state Supreme Court to embrace this animus argument, for which there is a pretty good precedent in the US Supreme Court. Well, I think most judges, all experts agree with Justice Jackson that CP sentencing rules make no sense and don't advance public safety. I think they're an example of the political exploitation of animus towards sexual offenders. Animus also explains, I think, the registry regime. And I think animus is clearly under the cases I told you about, is an impermissible purpose for purportedly civil regulation like the registry. I hope courts will someday agree. And that's what I leave you with now. Thank you. So I haven't heard a peep during my presentation. I could have, if a pin dropped, I wouldn't have heard that either. But so I assume that people could hear, because someone would have told me if
we just let you keep going.
Now I guess I can hear a little bit. So
it might be hard for you to hear, but if there are any questions, then go to the outside microphones and hopefully we can move some questions through.
I have a question. I don't know how much you know about computer forensics, but in 2015 at 2:30 in the morning,
let me interrupt. Someone's going to have to repeat what you're saying for me, because the clarity of the sound transmission is not good enough.
If I lean over, can you hear me better?
Did that make it better for you?
I could hear you. The person who just spoke, was that Andy?
Yeah.
Yeah, you're clear.
Go ahead, and I'll relay the question then. Go ahead.
In 2015, the FBI raided my home with flashbangs and M16s and questioned everybody. And they were salivating at the mouth because they thought they found somebody who had some pictures, but I didn't have any. And they were looking for somebody with a Linux operating system, and my roommate had a Linux operating system. We had a server. And 7 years later, they returned my computers, and nobody got arrested. No charges were filed. I'm wondering if maybe some child porn passed through that server on destination to another location around the world, on the globe. You know how servers take traffic throughout. If you know anything about the web, servers take traffic throughout the whole globe and redistribute it to different places. What do you think happened there? Do you think maybe the neighbors were trying to run me out of the neighborhood, or?
You go on, Andy. Yeah, I think I got the gist. I think, but you go ahead and do a summary. I'll understand.
Is there much behind the idea that as if there is child porn traveling across the internet, it moves from an intermediate device, and that's what then the law enforcement then sees upon? It's something in the middle of it going from A to B, but here's something in the middle. This is a highly technical question, obviously. How is this transported? And for a law professor, I'm pretty sophisticated technologically, but this is beyond me. My son is a software engineer, and I occasionally ask him questions. But I will just tell you that my understanding
of what happens is today, for the most part, right, are these file sharing programs like LimeWire is one that was used a lot. And these are the same sorts of programs that high school kids used to use to share pirated, music that was violating the copyright, and there was a big crackdown on these things. And it was a way for them to pass around and distribute the songs. Well, the same kind of technique is used. And so rather than having a single server, as I understand it, this stuff is distributed on all the computers all around that have accessed it. And so every single person who tries to look at some of these pictures by joining one of these file distribution networks is themselves also a server, because the images in their computer become accessible to other people who are on the thing. And so it was devised that way as a way originally for the people pirating music to avoid prosecution for violating their copyright laws, but it was repurposed to this. And so my understanding is that that's the most common method of transmission. There's not really one inherent server. And the other thing that I'll say is that when law enforcement, in my experience, when law enforcement catches people, they catch people because they find them in chat rooms that are on the dark web somewhere that they participate in which they're discussing the images, and maybe someone says, I have some I could share. And they then are able there, through IP addresses and whatever, to identify the computer that those chats are coming from. Then they seize the computer and they find the images. So I think, inadvertence is probably not likely in cases like that. And I'm not ruling out that possibility altogether. I'm just talking about the sorts of situations I'm familiar with. That's what I'm familiar with. But any event, that's my answer.
Question from the online live stream. Do you know any statistics regarding CP lookers with autism? Have there been significant downward departures?
Yeah, no, Andy, could you repeat it? Thank you. Oh, I don't know. There's this young man who was on the autistic spectrum, who's written a book. I've seen presentations by him. Maybe you have. And people on that spectrum often have a more difficult time discerning appropriate from inappropriate behavior than people who are not so afflicted. And I think that's part of the point that's made in some of his talks. And they certainly are unlikely to be harboring any kind of evil intent, because that also is kind of inconsistent with their condition. And so people who get caught up that way certainly are particularly sympathetic, at least from my perspective. I feel particularly bad that they are getting caught up in this prosecutorial web. But I don't know how common that is. An awful lot of people get caught up in it who clearly aren't on that. That's not their problem. I'll tell you, if you're looking for who gets caught up in it, there's a pattern that I keep encountering, and it's hardly a scientific survey. But, in the work I've done, I've encountered a particular pattern, and it struck me because it sort of was consistent with Wesley Hawkins, the guy who got the 3-month sentence from Judge Jackson. And that's a pattern in which somebody who's not come out as gay and who maybe isn't sure themselves that they're gay are looking at pictures of boys. And then they sort of confront their own sexuality for the first time when they're arrested for child pornography. They've never told anybody about it. It's remarkable to me how, just in my limited experience, how often I've come across that particular fact pattern. So it strikes me that maybe, there's something there. I mean, it's particularly tragic, I think, when you think about it. I mean, this is somebody who's exploring, trying to figure themselves out. They're not somebody trying to do anyone harm.
Professor Ellman, can you hear me?
Yes.
All right. My name is Gilbert Schaffnet. I'm an attorney in Gainesville, Florida, and I do a lot of work with the registry. First of all, it's an honor to hear from someone that clerked for William O. Douglas. I missed him when he came to Gainesville right before he died. So it's an honor to hear from somebody that clerked for him. I have a question about the Florida registry. We don't use a tiering system. There are some individuals that are eligible to petition to be removed after 25 years, but there are also a category of offenders that can never be removed. Florida, like Alaska, has a privacy constitutional amendment in their state constitution. The first question is, what are your thoughts on the possibility that the Florida constitutional privacy provision would win the day like it did in Alaska? The second is this: Florida also has a constitutional provision that prohibits denying access to the courts. And in Florida, you cannot petition to be removed from the registry even if you can prove, in some cases beyond a reasonable doubt, that you are no longer a danger and therefore should not be on the registry. The Florida Supreme Court used that provision to strike down a provision of the worker compensation law where there was an exclusive remedy of going through worker compensation, and then when they changed the law and basically nobody had the right to get compensation under the worker compensation law, they used that access to the courts provision to strike down the law and say that the law was unconstitutional because it deprived people of their day in court. What are your thoughts?
Well, it's two different legal theories that you're asking about. So let me, I'll do them in reverse order. So I don't know about, because I don't know anything about the access to the courts rule. That you tell me it's in the Florida Constitution, and it's an interesting idea. And maybe there are other states that have similar provisions, but that's not one I have any experience with. So how the Florida courts might apply that to this registry issue is, I don't feel very competent to comment on that. I will say that South Carolina Supreme Court did not rely on that, I don't think, if I remember correctly. They basically, the lawyers in the room will know what I'm talking about when I refer to substantive due process. And basically that's what the South Carolina state Supreme Court did in throwing out a law that's very similar to the Florida laws you describe it, because South Carolina also does not allow it. It's a lifetime registry for everybody. California had that until a couple of years ago when the legislature finally changed it. But in California, they finally changed. It. A wonderful example of Animus, not so wonderful if you're a target of it, and some people close to me are. But when they did that in California, the change originally was going to put people convicted of possession of CP in the lowest tier. They could get off after 10 years. There was the bee in the bonnet of one of the chair of the Appropriations Committee that ended up making that a lifetime offense. So people who convicted of possession in California remain on the registry for life. And that's a long story, but it's an interesting example of animus and of a Democrat not being very sensible about this. So I've thought here in California, which also has a privacy provision, of trying to work from the Alaska case and make the same sort of argument and say, with respect to the registry in California, you can't, because if you're on the registry, of course, you're on the public website, unless you're in tier 1. So you can't put all these people on the website for the same reason. And there is a difference, I discovered, between the Alaska privacy provision and the California one. And I don't know if this would also be true where it would come out in Florida. But as to those two, there's a difference in the legal test that's applied when the issue is the confidentiality of information as a privacy right as compared to a different sort of privacy right, which is the right to make very private decisions like reproductive decisions, which is also generally thought of as being part of the privacy right. So in Alaska, they protect the privacy of information very strongly. That requires the test of a compelling state interest. And that's why they were able to strike. That's why they were able to say you have to let people have a chance to protect this and not make it on the website no matter what. You have to give them an opportunity to show it. It's not justified in their case. California doesn't protect informational privacy quite as strongly in their privacy provision. They protect it, but the test is not as strong. So I don't know where Florida would come out, but it strikes me that there may be some Florida state court decisions that illuminate that. But I certainly am not familiar with them.
Ira, thank you very much. It's been great having you join us today. We wish you could have been here in person, but understand the circumstances, and we certainly thank you for your time and insight today. So,
well, thank you. I wish I could have been there too. I really do. There's a lot of people I would have been happy to spend time with. So, bye-bye.